folks? Why? No, I'm going to give it to Lee. Why are you up here?
You don't put it on the front, yes.
This is that one.
Yeah. However, she filed more stuff. Depending.
Okay.
Yeah.
Thank you. Court does call the case of BMC Rio LLC versus Nettie Whitlow and Yolanda Whitlow Tice.
Good morning, Your Honor.
Good morning, sir.
Good morning, Your Honor.
Good morning. State your appearance, please.
All right. Ian Redmond, P70599, on behalf of the plaintiff.
And your name, ma'am?
Doshia Banks occupant.
Pardon?
Doshia Banks occupant.
Doshia Banks, occupant, Your Honor.
Buckle up, guys. Today we are diving into a wild ride through 3 separate courtroom showdowns with sovereign citizens. First up, we got a squatter in Judge Simpson's court running the classic sovereign citizen real estate scam. And yes, the creator is filming from Turkey, fresh from dental work, but ready to break it all down. From fraud to defiance, this one's got everything.
Okay. So you're not Miss Whitlow?
No.
So what is your position in this case as you see it?
If I may, Your Honor.
Okay, good. Go ahead.
Ms. Banks claims to be an occupant of the property. She filed a bankruptcy case listing the property as hers. The bankruptcy stay was lifted, which gave rise to our motion to reopen the case. The order lifting stay I would like to present to the court because it has some interesting language in it, Your Honor, which includes, it is further ordered that the bankruptcy court finding this filing of this petition was part of a scheme to delay, hinder, and defraud VMC REO LLC. Additionally, Your Honor, the bankruptcy court ordered, notwithstanding Rule 4001A3, a bankruptcy rule,
Right.
creditor VMC REO LLC may execute on its order immediately. The order shall be binding and effective despite any conversion of this bankruptcy case to a case under any other chapter of Title 11 of the United States Bankruptcy Code. Further, that the recording with the appropriate governmental entity of this order shall constitute a bar to refiling any case under any chapter of Title 11 of the United States Code as to the property located at Pinecrest Estates Drive, Ann Arbor, Michigan, the property in this case. A debtor in subsequent case under this title may move from relief from this order based upon a change of circumstances or for good cause shown after notice and hearing. Said bar shall be for 2 years from the entry of this order or until such time creditor relinquishes their rights to the property. This order came out June 24th of this year. I have a copy for you. I will note, Your Honor, that Ms. Banks has filed an appeal of that order in the federal Eastern District of Michigan. That appeal is pending, but the status quo as of right now is that there is no stay, and that order lifting stay holds until such time as the appellate court does something.
The plaintiff's attorney lays out how the occupant filed bogus bankruptcies to stall eviction. The court lifts the stay, exposing a scheme to delay and defraud. Judge Simpson listens patiently but makes it clear there's no magic paperwork to dodge the law. The sovereign citizen insists on occupancy rights, but the law and the judge aren't buying for 1 second.
Additionally, Your Honor,
Yes, go ahead.
Additionally, Your Honor, there is no stay from the appellate court. They have not issued a stay, and in fact, it would be appropriate that there would be a bond placed or an escrow order of some sort, because BMC has been the owner of this property for the past year and does not have access to it. Additionally, Your Honor,
There's more. Go ahead.
there's a lot going on.
Yes.
Additionally, Your Honor, Ms. Whitlow, who, as far as I know, actually exists, but I don't have any evidence to that effect, has not appeared in any hearings in this court, did not appear for her deposition that she was noticed for in the federal case, and in a federal case, the federal court issued a show cause order to Ms. Whitlow that she had to present certain documents from this court, which she failed to do. Her deadline to do so was, I believe, July 3rd. Let me confirm that. Oh no, July 10th. And she did not supply.
Details pile up. $1 million home foreclosed and tied up in multiple fake bankruptcy filings. Even someone from Arizona tried claiming it as their residence. The judge hears how the occupant banned from preparing bankruptcies keeps filing anyway. It's a textbook sovereign citizen move, clogging courts with nonsense while living rent-free. The scam was unraveling fast.
By any of those documents. I can present that show cause order if you would like.
I don't know that I need that because
Okay.
I'm not.
The reason that I mention all of this, Your Honor,
Go ahead.
is that this is $1 million house in Ann Arbor that Ms. Whitlow purchased with a mortgage and less than a year later defaulted. The foreclosure went through, the sale occurred, the redemption period expired, and we came forward to evict. Since then, there have been multiple bankruptcies. Ms. Whitlow filed 2 different bankruptcy cases. A young man who apparently lives in Arizona filed a bankruptcy case and listed this property as his residence. Ms. Banks has filed a bankruptcy case and listed the property as her residence. It should also be noted that Ms. Banks was a bankruptcy preparer and has been forbidden from the bankruptcy court from preparing bankruptcies for anyone other than herself. The order lifting the automatic stay talks about that scheme of fraud. I list all of these things to show that the scheme continues. And that's why we would like to reopen this case, because there is no stay in place. We would like to move forward with an immediate eviction, at most an 11-day vacate. And if for some reason that would not be amenable to the court, we would ask for an escrow order or a bond. On $1 million property, I think it would be reasonable that $10,000 a month rent would be reasonable.
Now the occupant finally speaks, nervously denying the court's jurisdiction, only to backtrack moments later. Judge Simpson isn't having it. He bluntly points out she isn't even a named party, meaning she has no legal standing here. The fraud argument collapses on itself, proving these sovereign citizen defenses only work on YouTube, not in an actual court.
Right. Thank you. Ma'am,
Yes, Your Honor?
what do you want to tell the court?
Well, just for 60 seconds, and then I wrote something up because I am nervous, quite nervous. But I, Doshia Banks, respectfully appear specially and conditionally for the sole purpose of protecting federally vested occupancy rights and oppose an unlawful state action. I expressly do not consent to this court's jurisdiction and do not.
Well, then
Any
you are
rights.
not a named party. So if you're not consenting to this court's jurisdiction, sit down.
Oh,
You can go because you're not a named party.
I have a lease.
You are not a named party on this. You may have a lease with someone else, and
No,
then
I have
you
a
can
lease.
go challenge it. With who?
Whitlow. Ms.
Then
Whitlow.
you need to go against Miss Whitlow.
Pardon me?
Then you may need to go against Miss Whitlow. But if you're not consenting to the jurisdiction of this court, you might as well just sit down. You are not a named party. I do not have to hear from you.
Oh, I see. So I need to,
I don't know what you need to do, but
well, let me respond.
to what? You're not consenting to the jurisdiction of this court. Why am I hearing from you?
I'm recanting
You're recanting what?
what I just stated.
Which part?
The part uh, that I stated that I'm not. Okay, I lost my spot. Not consenting to this court's jurisdiction, so I'm going to recant that
So you are consenting to this court's jurisdiction?
at this moment.
Well, no, it doesn't work that way. You don't get to say, well, now it's okay, and then not later say no.
Okay.
You know what? Here's the problem. You've not filed anything with this court. So I don't know why, on those grounds, why I'm here.
Okay. If I may, I do have time, I do believe, to go file an answer and counterclaim. I was just led under
An
false.
answer and
pretenses
counterclaim to what?
to their complaint for eviction.
You have a lease with, allegedly, with Miss Whitman.
Correct.
Then that is who you need to pursue it against.
Okay.
The judge explains contract law in simple terms. Her fight isn't with a plaintiff, but with a person she signed a lease with. The squatter finally grasps the reality. She's been aiming at the wrong target. The ruling is clear. The plaintiff gets the property back, eviction ordered, and any appeal requires a hefty bond. The sovereign citizen gimmick officially dies here.
Privity of contract to the extent there would be, or relationship as between the plaintiff in this case and you.
Okay, I'm not really understanding that.
Well, let me put it a little bit more simple. If I grant the relief of the plaintiff in this case and grant an order of a judgment and an order of eviction in
Okay.
10 days,
Okay.
any claim of your interest in that property, you have to go after the Whitlows because that's the only person you have a contract with. Allegedly have a contract with.
Okay. No, there is an actual contract.
I don't know that, man.
We've actually been.
I don't know that.
Okay. I know you don't know that 'cause it's not before you.
Correct.
I see. I see. So basically, the notice of removal that the Whitlows did,
They are not here. I don't know. I have documents that are not, that they filed with this court that are not signed. So I don't have to accept them. She has not appeared before this court, or they have not appeared before this court. And so, as far as I'm concerned, any relief they're requesting I can, and as of right, deny, and it should be denied also on the merits of whatever their motion is. But I can deny it because they're not here.
Okay. Again, stating to me, I want to make sure I'm clear that my issue is with the Whitlows, not with VMC.
Ma'am, I am not giving you legal advice.
No, I
You're
don't.
telling me that you have a contract. I do not know that you have a contract, but if you wish to enforce that contract, that's who you're going to have the issue with. You're not going to have the issue with the plaintiff in this case because they have rights on the property.
Okay. All right, Your Honor, I will speak with the Whitlows that I have finally got an understanding of everything. And I will speak with plaintiff's attorney as well and continue to communicate with Remax, who has came by the house several times.
Judge Simpson goes further, setting a $15,000 monthly appeal bond, way above what the occupant expected. Her stunned reaction says it all. That move makes stalling nearly impossible, forcing the squatter to leave or pay big. The judge steps out for a break, cementing his no-nonsense approach to sovereign citizen antics. Next, we head to Judge Shackelford's courtroom.
All right, good morning. I'm Judge Chungan. We are here on People of the City of Taylor versus Randall Crane. Good morning. I see Mr. Crane up on screen. Sir, I believe you are muted. If you could unmute, please. There we go. Good morning, sir. Would you state your name, please?
My name is Randall Timothy Crane.
Good morning, Mr. Crane. And on behalf of defendant, today we have, please.
James
Mr.
Kazicki. I'm the House Counsel. I spoke with Mr. Crane. We had a breakdown in communications. I don't believe I can go forward representing him. We do not,
Okay,
support the same theory of law.
Mr. Crane, sir, you do have the right to have a court-appointed attorney. Do you wish to have a court-appointed attorney, or are you going to represent yourself at this time? You could change your mind later on, but at this stage, sir, are you representing yourself?
Enter Randall Crane, another sovereign citizen, already clashing with his court-appointed lawyer because their theories of law don't align. Translation: the lawyer actually follows real law, and Randall believes in internet myths. The judge calmly explains the arraignment process, but it's clear we're in for another pseudo-legal meltdown. It's deja vu with a new face.
Sir, me and the House Counsel do not agree on a bunch of things.
I understand that. My question is, all you're here for today is I'm going to actually give you the formal arraignment and conduct a pretrial. All I'm wondering, sir, is are you going to represent yourself at this limited proceeding? That's all, sir.
I would like to have a assistance.
Okay, all right, but at this time, we do not have other counsel. But what I am going to do is what we call an arraignment. All arraignment, sir, is just a formal reading of the charges that are lodged against you. That's all it is, and I explained that the rights that you have.
Well, I understand my rights.
Crane insists on representing himself, but doesn't want to follow basic procedure. The judge spells out the charges: obstructing an officer, a misdemeanor with potential jail time. Instead of focusing on his defense, Crane dives into sovereign citizen talking points, which are about as effective as arguing gravity doesn't exist. This isn't going his way.
Hold on just a minute. I want to make sure I have the complete file. Mr. Guzicki, maybe you can offer a little assistance, sir. Okay, no, I've got it. So, for the record, Mr. Crane You're here for an arraignment. As I explained, sir, arraignment is that initial stage of the criminal proceedings, or simply put, you're advised of the charges that are now formally lodged against you. I'm going to advise you of the rights that you have. You plead, after I'm done with that, then you plead guilty or not guilty. After that, sir, the next stage is something called a pre-trial conference. That's where you, if you're representing yourself, or you with your court-appointed attorney, you sit down with the prosecutor and discuss the merits of the case. Okay, sir, so in this matter, you are charged on the complaint of Taylor PD Officer Schillenberg, who states that on March 26th, while in the city of Taylor, that you obstructed the officer from performing his lawful duties, specifically with respect to the stop on where he claims he observed you operating electronic device. Now, a misdemeanor charge in the state of Michigan. It's a criminal offense. It subjects you potentially to be 0 days in jail up to 90 days. Fines could be 0 up to 500. You could be placed on probation also for a period of up to 2 years. Of course, you have the right to have an attorney to represent you. If you can't afford one, one could be appointed. Of course, you start out with the presumption of innocence. You close with that presumption all the way through, unless and until the jury finds out or a judge rules the other way. Now, of course, you have the right to have a trial. The trial could be heard by a jury or a judge. At trial, sir, you and your attorney have the right to cross-examine all of the prosecution's witnesses. You could bring in witnesses that would testify on your behalf, and you could testify or not testify as you see fit. If you choose to remain silent, it can never be held against you. For example,
The judge explains rights, trial processes, and penalties, but Crane is stuck on rejecting jurisdiction. It's another classic moment. Sovereign citizens can't grasp that rejecting a court's authority doesn't make it vanish. After setting pre-trial dates, the judge handles him firmly yet fairly, refusing to indulge nonsense. Another loss for internet legal theories.
well done. Now, having heard that charge, how do you plead to the charge of obstructing the officer? All right, I'm going to note that the defendant stands mute. Has the same effect, sir, as you pleading not guilty. Now, sir, you are going to have I need you to write this down, please. You will have a pre-trial conference where you're going to meet with an attorney here in the court. I'll write this date down, July 16th at 9 a.m. It's an in-person pre-trial conference. Furthermore, sir, we're going to mail a notice of that date to the address that's listed on your ticket. Not going to state the address now because this could go out for further public consumption. Not going to do that. But note, sir, July 16th, 9 a.m. All right. And at this time, I'm going to release you on a personal bond. You don't have to post cash. That's your word that you're going to come back on the July 16th date at 9 a.m.
Well, look at that. He actually.
Crane stands mute, which legally equals a not guilty plea. The judge releases him on a personal bond and gives him a court date. For a second, it looks like things are normal, but then comes a curveball. Crane declares he's billing the court $1,400 for his time. Judges have heard this before, and just like always, it goes nowhere fast. Part 11, 25:31, 27:26. The judge explains again, show up to court or face consequences. But Crane digs in, saying he doesn't understand the jurisdiction. It's like watching someone argue with gravity while falling off a cliff. The judge brushes it aside, moves forward, and leaves Crane stuck with reality. His sovereign fee schedule won't save him from legal obligations.
All right, sir. Now, I also want to inform you, we have a couple of other charges. They're called civil infractions. One has to do with no proof of insurance and no registration. Sir, these being civil infractions, you can't be sent to jail for these. They're simply not criminal offenses. All right. You'd be fined up to $100 on each of those, but you can't be sent to jail. Just for your information, they are accompanying charges. So again, sir, today, you've stood mute. I'm going to note you're requesting appointed counsel. I'm also noting for the record you had spoken with Mr. Kazicki and he's not able to represent you any further. And lastly, again, you're on a personal bond. That's your word that you're going to come back on that July 16th date. Understood, sir?
No, I do not understand.
Pardon me, sir?
No, I do not understand.
Well, I'll explain it again. You come back on July 16th in court for a pretrial conference. You meet with the attorney who will meet with the prosecutor. That's when they discuss the merits of the case. And right now, I've released you on a personal bond. You don't have to come to the courthouse and post any money. It's your word that you're coming back on that date. I've notified you here on the record of the court date, and further, you'll be mailed a notice.
Yes, Your Honor, I understand that part. But what I don't understand is I
30:06. We jump to Thurston County, where familiar face returns. This sovereign citizen previously convinced some viewers he wasn't one at all. Today, he drops the mask, claiming conspiracies and right to travel arguments. But his misunderstanding of law becomes painfully obvious. It's a crash course in why YouTube law gurus don't stand up in actual courts.
I didn't come prepared to contest the infractions.
Well, that'll be easy, because tell me whether you have insurance or not, but hold on a second,
sure.
Let me just explain. Failure to transfer title, the trip permit, and the driving suspended charges, which are all criminal charges. And those are the ones that you'd filed all the pleadings on, which I've read all your pleadings.
Okay. You have any comments on it? Just curious.
I'll give you my comments here in a moment. So, without ruling on anything that might be filed on the new case, I'll just share some thoughts with you, which are that the view that you set forth in your pleadings is, we see that occasionally, very similar language. I don't know, sometimes the briefs we get in this line are all read the exact same. Yours is not the exact same, but a lot of language.
The judge explains the basics. Driving is a regulated privilege, not an unrestricted right, and vehicle registration supports public roads. The defendant argues registering a car makes it commercial, proving his deep in sovereign citizen ideology. But the court makes it clear, no paperwork loopholes will turn public roads into his personal playground.
Exact same. There is no case in the country that says a state cannot regulate the driving, both commercial and private, on any public thoroughfare. So, I read your arguments as to why you believe the freedom of travel means you can drive your private vehicle on public roads, which are paid for by the registration of the vehicle, by the way, in part. That you believe you can drive because you have the constitutional right to travel. That it's never been interpreted that way. So the constitutional right to travel does not apply to overcome the requirements that states have imposed to require you to register your vehicle on an annual basis. That is it. I pay my registration fees every year because I have to, in order, if I want to put my car on the road. And I know if I put my car on the road with expired tabs, I'm going to get stopped and I'll have to pay the fine and I'll have to go get my car tabbed. I just know that's the way it works. And that's how the system is set up. So there's no legal argument there. You know, you made it in a sort of a big way, but I think it's a misinterpretation of what you believe the right to travel is. It does not give you the right to travel in any state, not adhering to that state's laws. And every state has a registration law like the state of Washington. So you've asked for my general.
Have you noticed that in courts, a car is referred to as a motor vehicle? A friend riding with you in the car is referred to as a passenger. You're engaged in traffic, and what the problem is, when a person registers his private property automobile with the state, he's declaring it a commercial vehicle.
No, that's your interpretation, and I'll just tell you that's not the interpretation shared by the courts. We don't see it that way at all. So the law makes very clear that all of us who have vehicles that we put on our roads, they have to be registered. Doesn't matter whether we have passengers, no passengers, if we drive them ourselves or not, if we're engaged solely in personal business or moving from point A to point B, none of that exempts us from the requirement to appropriately register our vehicles, which is used as a means of supporting the construction of the roads that we drive.
Yeah, you know what? You said you've seen a few of these. What compels people to do this is the state abusing its power to license drivers, as well as doctors and other professionals. If you don't behave the way the state wants you to in your private life, in your family life, the state, through the family court, can have your license suspended. And that's just strong evidence that the system is not set up to make the road safe, but to control people. And people don't like that.
They debate license suspensions tied to child support enforcement, with the defendant calling it government control. The judge reminds him these laws aren't optional, and no court has upheld his version of freedom to travel. It's another reality check. Personal philosophies don't override established law, and sovereign citizens keep learning that the hard way.
Yeah, I understand the philosophy behind that. We don't do anything here with suspending licenses or not. We just interpret whether the person has a license or doesn't have a license. That's the only rule of the court there. Now, I will say what you're referring to is the ability of the Department of Licensing to suspend licenses for the failure to pay child support as
It's
ordered.
government support.
What's that?
It's not child support, it's government support.
Okay, well, it's called child support. And that's what it's, you know, if you look on your driving record, you have one of those things there that says, it says failure to pay child support. I understand there's a different way of looking at it. But it is not directly related to driving, I get that, but the legislature made that, they thought, how can we leverage people to pay what a court has determined they should pay for the support of their children. And they decided that one good way to do it was to leverage the ability to drive. So that's what the legislature decided to do. They created the law. Nobody has determined that law is unconstitutional.
A lot of people have, but they haven't taken it.
Right.
So in family court, the court rules don't apply. You know that. And due process is streamlined. So your driver's license can be suspended through a court procedure where it's a free-for-all. I've seen it.
Okay. Yeah. So I like I said, I understand the philosophy you're indicating. When the case comes to me on a driving suspended charge, I look to see if your license is active or if you don't have the privilege to drive on the state. And you view it as a right. The law views it as a privilege, and the privilege is enacted if you are properly registered and insured.
Well, it's a privilege to operate a motor vehicle on the highways, but the courts have ruled, and it's in my brief, it's a right to travel by your automobile, by your private property automobile.
No, there's no court. Like I said, you can look all you want, but nobody has ever found a case that says a court upheld the ability of somebody to drive in whatever state on public roads.
Well, driving is a commercial term too.
Okay. To operate a motor vehicle in any regard.
That's even more a commercial term. Look at
To
other
operate your
blocks.
car. No, there's no case that says you can
Operate
operate your
means
car.
using a business machine
Okay.
on a
Yeah.
public utility.
No, that doesn't. Operate means I'm operating my computer. I'm operating
That's a colloquial.
my pencil.
That's a
Okay,
colloquial
well,
term.
then you're pushing your example into sort
Look
of
at
a,
Black's 5th edition. You'll see that operate means using a business machine for gain.
okay. I disagree with that, and
The judge concludes driving is a privilege requiring compliance, period. The sovereign citizen is left with no legal win, only a future court date he can't talk his way out of. Across 3 cases, sovereign citizens tried every trick and failed. The law stood firm, judges stayed patient, and fraud crumbled. Don't forget to like the video, subscribe to the channel, and we'll see you in the next video.
I don't think you'll find any cases that say.
Okay,
So,
I appreciate
okay.
your input.
All right.
Thank you.
But we'll see you on the 5th of August.
Okay.
All right. Bye-bye.